Happy New Year, everyone. My name's Angus Rankin. I'm a partner in V&E London's construction team. I'd like to say a few words about a 2024 English High Court decision, Tata Consulting Services and Disclosure and Barring Service. This is an IT case, not a construction case, but as so often happens, a technology case has much to teach construction lawyers. Think back to Triple Point and PTT, or Stereo and Sigma, for example. So the Tata case raises a number of interesting points, and these were considered by Mr. Justice Constable, a past attendee and panelist at this very conference, I might add. I'm going to focus in particular, though, on claim notices as a condition precedent and an estoppel argument that assisted the contractor and got them out of a potential time bar. The story is as follows. The project fell into delay with much finger-pointing as to the cause. The contractor was bound by a number of different obligations around serving claim notices. Delay claims had to be made as soon as reasonably practicable, and more particularized notices had to follow 5 working days after the initial notice. It was common ground that the contractor never met this 5-day notice deadline. It became a live issue in the case whether those notice obligations amounted to a condition precedent. The judge held that they did, and in so doing, he delivers an extremely useful roundup of the case authorities in that area. But although the contractor did not succeed on the condition precedent point, the contractor raised a number of other arguments to excuse its lack of notice, and these are well worth a look. The contractor argued that there was an express agreement with the employer that the 5-day notice deadline did not have to be complied with. No express agreement was held to exist, however, although the contractor did write to the employer seeking an extension to the 5-day deadline. The employer's response was too ambiguous to constitute acceptance. To compound matters later on, when the contractor did serve its notice, it added a somewhat barbed comment to the effect that the employer had never responded previously, a reminder perhaps that in the heat of drafting project correspondence, it's easy to lose sight sometimes of how best to preserve all your arguments for the fight that may come later. But what's really interesting about this case is that the contractor did succeed on an argument that an estoppel by convention had arisen, i.e. 1, there was a common assumption between the contractor and the employer that the 5 days could be departed from. 2, this was communicated between the parties. And 3, the contractor, knowing the employer shared that assumption, strengthened the contractor's reliance on that assumption. The estoppel arose in an interesting way because in parallel, around the time that the contractor should have served its notice, the parties were engaged in negotiations to re-baseline the project program and reach commercial agreement on a number of different matters. The court believed the contractor's fact witness when he explained it was understood on both sides that these discussions about re-baselining the program and trying to reach commercial settlement effectively suspended the requirement to give notice while those discussions were ongoing, not least because the settlement negotiations could have impacted on what a contractor claim notice would be seeking. And on the employer's side, there was evidence that this assumption was shared by them as well. Give this case a closer look. If you're the employer and you want the contract notices regime to keep functioning in parallel to settlement discussions, thereby preserving the opportunity to time bar your contractors, then you might need to take particular care in making sure that that happens and that the notices continue to be served in parallel. Conversely, if you are the contractor and you are in difficulty on notices, as is so often the case, there may be an angle here, and if you go through Tata Consulting and the Disclosure and Barring Services case, it's really a compendium of different arguments that a contractor might raise. Thank you. Happy New Year.
My name's Annalisa Day, KC. I'm from Fountain Court Chambers, and I'm going to talk today about the key trends in international construction arbitration that I've seen during the past year. So the first trend that's been apparent to me is an increased use of technology. I think that's been used this year even more to streamline proceedings and enhance efficiency. From virtual hearings to electronic document management to online arbitration platforms, technology is revolutionizing the way construction disputes are resolved. Many arbitrators are now working purely electronically, and remote hearings are being used both for preliminary and final hearings, making those easier to schedule and allowing efficient and quick case management decisions. The parties, their representatives, and arbitrators are all starting to explore AI tools. This is a rapidly developing area. You need to be in the know about that and to watch out for new developments each week, let alone each year. So the second thing that I've noticed is an emphasis on efficiency and cost effectiveness. This is what parties are really interested in, resolving their disputes fairly but efficiently. And I've seen arbitrators and parties employing various strategies to streamline the arbitration process, such as shortening deadlines, limiting discovery, using witness statements, adopting expedited procedures for smaller claims, and additionally case management techniques to seek to control costs and make those proceedings as efficient as possible. In particular, I've seen the rise of arbitrators using case management hearings remotely to speak directly to experts, to seek to ensure that they are on the right path for the final hearing. And in many cases, that can be incredibly effective and efficient. Thirdly, there's been a rise in the past year of delay, disruption, and cost overrun claims. Everyone's favorite topic. Lots of these claims are not settling, in my experience, but going to a hearing, both because of the sums involved and because there may be difficulties proving these claims. We are seeing, I think, the long tail of COVID and supply chain disruption. These claims present particular challenges, especially in relation to disruption and separating out the impact of different causes on the project schedule. I cannot emphasize enough the importance of keeping good records of the impact that such events may have on your projects. The final trend that I wanted to talk about today is the extent to which arbitrations are becoming increasingly expert dependent, particularly given the applicable codes and the nature of the claims, which on any given construction project can require significant expertise. It's incredibly important to get a good expert in place early on to ensure that you have a choice in that regard and that you have someone independent, competent, advising you from the beginning. By understanding and addressing the technical issues proactively, parties put themselves ahead of their competitors and allow themselves to navigate the arbitration proceedings much more effectively and to achieve timely and cost-efficient resolution to their disputes. Achieving a meaningful and effective dialogue between each party's experts is incredibly important to unlocking and making progress to the timely and cost-efficient way of resolving proceedings. In the UK, we've seen some developments where courts have disapproved of experts not acting independently, and I've also seen within the international arbitration sphere a similar thing happening with arbitrators taking a much more hands-on approach, speaking to experts directly and seeking to ensure that areas of agreement are identified as early as possible.
Hi, my name is Hugh Saunders. I'm a barrister specialising in construction, engineering and technology disputes. I practice from 4 New Square Chambers, and I'm going to talk today about Toppleson and Rolls-Royce, a recent decision of the Court of Appeal handed down in November. The case is about the way that contractual liability caps interact with claims for set-offs and other claims, and indeed interest. And I think it's of general interest because these sorts of contracts typically contain these sorts of liability caps, whether they're under English law or law in other systems. The facts are relatively straightforward. There was a contract between Toppleson and Rolls-Royce for some IT services for their website. There were delays and problems with the project. The contract was terminated. Toppleson sued for its fees and Rolls-Royce counterclaimed for its losses. At trial, the judge decided that when she deducted the fees due to Toppleson from the damages due to Rolls-Royce, there was a net sum payable to Rolls-Royce of about 7.1 million euros. She reduced that to 5 million euros by applying the contractual liability cap. Toppleson appealed that judgment, and whilst there were a number of side issues, the main point of Toppelson's case was that the liability cap should have been applied to Rolls-Royce's losses before the fees due to Toppleson were taken into account. If that was correct, that would reduce the damages payable overall from 5 million euros to about 4.2 million euros. There are two clauses in the contract that are relevant to this point. The first one was the limitation of liability clause. That clause said that the total liability, and those words were important to the judgment, of either party to the other under the agreement was going to be limited in aggregate for all claims to 5 million euro. The second relevant clause was the termination clause, which allowed Rolls-Royce to terminate the contract, and it said that the Rolls-Royce's sole liability in those circumstances would be to pay the outstanding fees that were due to Toppleson for work done before the termination. The Court of Appeal decided that the judge had wrongly applied the liability cap. They said that what she should have done was first calculate the damages due to Rolls-Royce, second apply the liability cap, which reduced those damages to 5 million euros, third calculate the damages due to Toppleson, and then set that sum off against the 5 million capped sum, leaving the balance of 4.2 million euros payable. The main reason why the Court of Appeal made this decision was the wording of the limitation of liability clause itself, but the court also thought that this made commercial sense. If this wasn't the correct way to construe the cap, then Rolls-Royce could effectively recover more than 5 million euros simply by the expedient of not paying invoices to Toppleson before the termination. That was a particularly relevant consideration for the Court of Appeal, where the sole liability following termination for Rolls-Royce was the outstanding fees. I think this is an interesting point because lots of liability caps in lots of contracts around the world are worded in a very similar way to this liability cap. In my own practice, I've seen these sorts of provisions in FIDIC contracts for works all over the world, as well as in bespoke contracts for various matters. Usually, often in fact, a claimant might think that if its claim overtops both the liability cap and any outstanding fees that might be payable to the counterparty, then it will at least recover the maximum sum due under the cap. What this judgment tells us is that is not always or even likely to be the result. In an extreme example, if, say, the fees that were due to the counterparty were equal to the sum of the cap, the net sum payable at the end of any trial might be nothing. The Court of Appeal said that this was how the clause was supposed to work, and if the parties wanted to achieve something different, they would have to word the clause of their contract differently. As a separate part of the decision, the Court of Appeal also found that the interest payable for late payments wasn't subject to the cap. That, at least, I think, would probably be in accordance with what most people would have thought would be the result. So what's the takeaway? Your contractual liability cap probably doesn't work the way you think your contractual liability cap works. And just because your claim is more than the cap and possibly more than the fees you owe to the other party doesn't mean you're going to recover everything under the liability cap.
Hi, my name is Giuliano, associate at Vinson Elkins and based in our Dubai office. And today we'll talk about the introduction of the civil transactions law in Saudi Arabia, also known as the KSA Civil Code. Now, this is a landmark development because for the first time, Saudi Arabia has codified its civil laws governing a wide range of matters, from contracts to property rights, which were previously based entirely or almost entirely on Sharia principles as interpreted by judges on a case-by-case basis, which inevitably often led to inconsistent outcomes. The Civil Code spans over 700 articles, reflecting the wide scope of the code This is a landmark development because for the first time, Saudi Arabia has codified its civil laws governing a wide range of matters, from contracts to property rights, which were previously based entirely or almost entirely on Sharia principles as interpreted by judges on a case-by-case basis, which inevitably often led to inconsistent outcomes. Now, the Civil Code spans over 700 articles, reflecting its very wide scope. But today I want to focus on provisions regarding liquidated damages, a contractual tool extensively used in the construction contracts, allowing parties to predetermine potential liabilities. For context, prior to the Civil Code, the validity of liquidated damages clauses was unclear, mostly due to concerns about the compatibility with Sharia law. But now the Civil Code finally addresses this issue by clarifying that parties can pre-agree on compensation amounts for breaches of contracts. However, notably, courts or arbitral tribunals retain discretion to adjust these amounts in three key scenarios. First, if no actual damage occurred, the pre-agreed compensation would not be enforceable. Second, if the agreed compensation is disproportionately high relative to the actual losses, it may be reduced. And finally, if the respondent's fraudulent actions or gross errors cause greater loss than the agreed amount, then the courts can actually increase compensation to reflect the actual damages. And it is important to note that this is very much in line with the approach adopted by many civil jurisdictions in the region, which seek to strike a balance between, on one hand, party autonomy by allowing parties the freedom to pre-agree on damages, whilst on the other, ensuring fairer outcomes. And overall, these and the other changes brought about by the case-safe Civil Code offer greater clarity and certainty to contractors and employers operating in Saudi Arabia. But as a final word of caution, please do note that the new Civil Code remains largely untested, and therefore remains to be seen how the Saudi courts will interpret these provisions in the coming years. So please do watch this space.
My name's Sanjay Patel, KC. I'm a barrister at Four Pump Court Chambers in London, and I'll be speaking about a recent Supreme Court decision in the case of the Crown on the application of Cobalt Data Centre against HMRC. In construction circles, the case of the Crown on the application of Cobalt Data Centre against HMRC hasn't garnered very much attention since it was handed down in November 2024. And perhaps that's fair enough, because on the face of it, it looks like a tax case, and it's really all about the Capital Allowances Act of 2001. However, what you might not know is that the decision is now the leading case on the scope and effects of variations clauses under the JCT standard form. The decision is quite surprising and very relevant to a wave of construction disputes around the world. So what was the case about? The case concerned valuable tax incentives to invest in enterprise zones. A taxpayer was entitled to 100% capital allowance under section 2981 of the Capital Allowances Act of 2001 if it made an expenditure, A, 10 years after the site was first included in the zone, or B, if the expenditure is incurred under a contract entered into within those 10 years, 20 years after the site was first included in the zone. So the case was all about whether or not expenditure under a varied building contract could be treated as being under a contract entered into within the initial 10-year period. So what was this enterprise zone all about? Well, the relevant enterprise zone in Tyneside was established in 1996, which meant that a taxpayer would only be entitled to capital allowances in relation to contracts entered into before February 2006. And 2 days before the end of the 10-year period, two wholly owned and controlled special purpose subsidiaries of the same corporate parent made what was called a golden contract. And that was a contract on amended JCT terms, which contained various different work options for different projects that might be built. These included the manufacture of an industrial unit and a business park. Over the course of the next few years, the employer exercised the contractual right that it thought it had under Clause 12 of the JCT contract to vary the works options substantially. And it didn't build an industrial unit, it didn't build a business park, but instead it built 3 data centres and varied the contract to that effect. Now the question was it within the scope of the employer's unilateral power to vary the contracts to build these 3 data centres such that the work executed under a contract was executed within the initial 10-year period? Or was the unilateral power to vary the contract under Clause 12 of the JCT contract insufficiently wide, so the work to build the data centre was not under the contract entered into in the first 10 years of the enterprise zone? Well, the Supreme Court found against Cobalt Data Centre and found at paragraph 116 of the judgment that the variation power only bites if what is sought to be substituted by the requested change is still design, quality and quantities of what is substantially the same building. So you can't execute a contract to build a business park and then vary it so that the subject matter of the contract is 3 data centres. The Supreme Court found that the Clause 12 power to vary was not sufficiently wide for the data centres to be treated as expenditure under the original contract. Now, on the merits of the case, you can see how that decision was reached. The Supreme Court clearly thought it was scotching a dodgy tax scheme. But as a matter of construction law, the idea that there are limits on the unilateral power to instruct variations is pretty foreign. What does substantially the same building mean? To take a totally hypothetical example, if there's a contract to construct a 10-kilometre long building and the employer decides to omit works in relation to 9 kilometres of that building, so it'll only be 10% of the original size, is the instructed change still in relation to design, quality and quantities of substantially the same building? Arguably not. So that in that scenario, perhaps the variation would not be valid and the instruction to omit would not bite. So who knows? Maybe in the coming years, where we know that there are very large projects that are subject to very large emissions, perhaps we'll all be making submissions about an English Supreme Court tax case.
My name is Kate Grange. I'm from 39 Essex Chambers, and my topic today is the implications of the Grenfell Tower inquiry report for litigation and non-contentious matters both here and abroad. The Phase 2 report of the Grenfell Tower inquiry was published on the 4th of September 2024 and has implications not only in the UK but also internationally, given some of its findings. In this briefing, I want to highlight some of the less well publicised aspects of the report which are of real significance when any question about the fire performance of external walls arises. First, the inquiry undertook a comprehensive review of the fire testing regime as it applied in England before the Grenfell fire. The inquiry dissected each of the small, medium and large-scale tests which made up the testing regime for external walls and examined what information would be obtained from each of those tests. It also did the same for the European reaction to fire testing regime, including the single burning item test. Having undertaken that examination, the inquiry went on later in the report, in chapter 111, to examine what information relevant to the assessment of external wall performance is actually provided by the current testing regime. The inquiry's conclusions in this regard are important. They have the potential to influence both litigation and more generally the development of testing regimes, not just in the UK, but also abroad, given the extent to which, for example, the large-scale BS 8414 tests, which are in use here, are not dissimilar to large-scale system tests which are carried out elsewhere around the globe. The key conclusions which were reached by the inquiry about the current testing regime were as follows. First, the particular fire safety strategy for the building is key. There's a need to understand what this provides for and check that the strategy is supported by all other active and passive fire safety measures in the building, including the external wall. Secondly, in the years before the Grenfell fire, the fire test methods available for determining the reaction to fire of materials, products and external wall systems did not provide designers with the information they needed to properly assess the risks of the fire spreading across the walls of the building. Thirdly, the functional or performance requirements for external walls and the relevant guidance did not fit with the stay-put strategy, which was the assumption for buildings in England before the Grenfell fire. Fourthly, although the report does not recommend abolishing the stay-put or defend-in-place strategy for high-rise residential buildings, there was a clear steer from the inquiry to move away from stay-put and instead assess walls according to the speed of fire spread and by calculating appropriate and conservative evacuation times as part of a phased or full evacuation strategy. The inquiry also concluded that if a building had a stay-put strategy, then any external fire spread should be no more than negligible. In its recommendations, the inquiry suggested that steps are taken to develop new test methods for assessing the performance of external walls, which will provide information for such assessments to be carried out reliably. These findings have the potential to affect the understanding and development of the testing regime, not just in the UK, but also internationally. The inquiry heard evidence from experts who'd worked in a number of different jurisdictions, and it's clear from its findings that the inquiry thought that more needed to be done to understand the science behind the spread of fire across such systems, and this needed to be prioritised so that disasters like Grenfell don't happen again.
Hello, I'm Mark Channels. I'm a barrister at Atkin Chambers in London, and the case I'd like to deal with is called Providence Building Services and Hexagon Housing Association. The case was a decision of the Court of Appeal, and it concerned the termination of a design and build contract by the contractor, Providence, for repeated late payment by the employer housing association, Hexagon. The issue for the Court of Appeal concerned the proper construction of Clause 8.9 of the 2016 JCT Standard Form, which is wording that remains in the new 2024 suite of standard forms. There are essentially three relevant parts to Clause 8.9. First, by Clause 8.9.1, the form stipulates that certain types of default or breach can, if the subject of a compliant notice from the contractor to the employer when they occur, become a specified default. Second, by Clause 8.9.3, if the default continues for a prescribed period, in this slightly amended contract 28 days, then the contractor can serve a notice terminating the contract. Third, by Clause 8.9.4, if the contractor for any reason does not give the further notice referred to in Clause 8.9.3, but whether previously repeated or not, the employer repeats a specified default, then the contractor can serve a notice of termination. The question for the Court of Appeal was as to whether, in order to be entitled to serve a notice of termination under Clause 8.9.4, when the employer repeated the specified default, the contractor must have previously had but not exercised the right to terminate under Clause 8.9.3. The Court of Appeal found for the contractor there was no need to have had the prior right to terminate. I'd like to make 6 short points about the decision. First, the case turned largely upon the wording of the provision, and in particular, if the contractor for any reason does not give the further notice referred to in Clause 8.9.3. That the specified default had ended before the right under 8.9.3 had accrued falls within any reason. Close regard to the party's chosen language is always crucial, but all the more so in the context of standard forms. Second, the court read those words in the context of the contract as a whole. A very similar formulation appears in the employer termination provisions at Clause 8.4, which supported the contractor's construction of the provision. Third, the effect of this decision is that, once there has been a notice of specified default, the employer is skating on thin ice indeed. It has in football terms its yellow card. Don't transgress again, or at least not in the same way. Fourth, remember this works both ways, in respect of both employer defaults and contractor defaults. What's sauce for the goose is, here, sauce for the gander. Fifth, there is a safeguard. The defaulting party retains the protection of the well-known proviso in Clause 8.2. Notice of termination shall not be given unreasonably or vexatiously. Sixth, the effect of the decision is to confirm that this form of words in the termination provision works in the same way as the corresponding provisions worked in the previous incarnations of the JCT form up until the introduction of this wording in the 2005 edition. As the Court of Appeal held, it is difficult to characterise the result as commercially unacceptable in that context. Permission to appeal to the Supreme Court has been sought by the employer, but not at the date of recording ruled upon. If it is given, watch this space for an update. provided that I win again. If I lose, I will hide and simply pretend that none of this ever happened.
Lucy Garrett from Keating Chambers, and I'm going to talk about conclusive evidence clauses. The issue of conclusive evidence clauses came before the TCC again in February 2024 in a case called Battersea and QFS. This is almost exactly a decade after the decision of the TCC in the University of Brighton and Dove House. I represented the losing side in both cases, so consider myself well qualified to discuss the points arising. Conclusive evidence clauses are found in a number of standard form contracts, in particular the JCT suite. They essentially provide the final statement will be conclusive evidence of various matters such as entitlement to extension of time and loss and expense, unless the parties take certain prescribed actions. These actions always include starting proceedings, which can include adjudication proceedings. In Dove House, a notice of adjudication had been issued, but the wrong nominating body had been identified, so that the first nominated adjudicator had to resign and the claiming party had to reissue a new notice and start new adjudication proceedings. This all took place within a day, but was outside the deadline in the conclusive evidence clause. It was held in Dove House that the first notice, though invalid for the adjudication, was sufficient to commence proceedings within the meaning of the clause. It was also held that if, on the facts, a party had effectively abandoned the adjudication, that would mean a notice wasn't sufficient to commence proceedings, but that had not happened on the facts in Dove House. In QFS, the clause was a bit different. It required proceedings to be commenced, but it went on, the final payment notice shall not have the effect specified in the clause in relation to the subject matter of those proceedings pending their conclusion. Upon such conclusion, the effect of the final payment notice shall be subject to the terms of any decision, award, or judgment in or settlement of such proceedings. So the clause had two stages. It required proceedings to be commenced and then stated what would happen on conclusion of such proceedings. On the facts as found in QFS, a notice of adjudication had been issued, but a referral had not been served by the claimant's choice by the agreed deadline. A new notice was issued, but 4 months later, and that adjudication proceeded to a decision. It was held in QFS that a conclusion meant a decision or a settlement. So an adjudication which became a nullity had not reached a conclusion for the purposes of the clause. It therefore did not matter that a second notice had to be issued, and therefore the proceedings had concluded with a decision that was 5 or 6 months later on. It was held that there is no necessity for the adjudication decision in question to be responsive to the specific notice of adjudication by which the adjudication proceedings were commenced. Consistent with the approach in the previous cases, including in Dove House, what matters, in line with the expectation of sensible businessmen, is that the decision is responsive to the subject matter of the dispute raised within time in respect of the final payment notice. Overall, I consider that to be a sensible, business-like construction of such proceedings. Further, it was also held that there had been no abandonment, either on the ground of the claimant's deliberate decision not to serve the referral, or on the ground of the time that had elapsed. The claimant had, it was held, objectively intended to pursue proceedings throughout. It will be seen that, exactly as in Dove House, the court was not interested in technical points and took pains to construe the clause widely where necessary in order to achieve a practical commercial solution, which meant that where a party had substantively started an adjudication, it would not be caught by the conclusive evidence clause. Further shows that on the facts it will be very difficult to establish abandonment, although this does remain a potential avenue for employers to explore in principle.